Good afternoon, everybody, and welcome to the next edition of the Bond and Botus Facebook Live. We've been doing these Facebook Live episodes for over 3 months now. Time has really gone by. We started at the beginning of COVID when a lot of us were forced to work from home, stay at home. Restrict our ability to get out and around, and we've just tried to provide information for our viewers as to different important topics. And today we're really fortunate to have a special guest. We have Arthur Ray, who is the Assistant General Counsel for the Alabama Department of Labor, and we're going to talk about the landscape for unemployment compensation benefits going forward. So, Arthur, welcome and thanks for joining us today.
Well, thank you for having me, Brad. It's really a privilege to be able to speak to folks about our unemployment system and how they can interface with it and some of the things that are changing given the current environment and some of the things we may expect to see going forward. So I really appreciate the opportunity.
Well, the information that you have and that you're able to provide is just invaluable to so many people going forward. I do want to give our viewers a little bit of background on Arthur. In addition to holding the very important position as Assistant General Counsel with the Department of Labor here in Alabama, you attended Auburn University, went on to Jones School of Law. I know you've served as a judge. You've had some experience in bankruptcy law, which is the area that the Bond and Botus law offices focus in. And you are married to Justice Kelly Wise, who serves on the Supreme Court of Alabama. Justice Wise also attended Auburn University. But it's my understanding that the smartest member of your family must be your daughter, because she's attending the University of Alabama currently. Is that correct? That Hannah Mathis.
Right. Somehow I knew that was going to come up. Yeah.
Sorry about that, Arthur. I was given that bit of information by a mutual friend of ours.
Yes,
I will share with our viewers that, one of the things attorneys do is when you are up against a new opposing counsel, you look to their bio a little bit and you see if you can learn anything. I'm glad Arthur and I are not opposing counsel, because I understand you also participated in the rugby club while you were at Auburn University.
Yes. In fact, my some friends of mine from law school who knew that I played rugby, and actually I'd played club side ball for so long. When I went back to Auburn to play, they asked me to both coach and play, which was an honor, and I appreciate that. But I've told friends of mine from law school, I said, I think the rugby experience was probably good to set me up for law practice, although obviously it's no longer physical contact, but maybe verbal contact. So, but yeah, it was quite an enjoyable few years that I did that.
I found that very interesting. I know that's a tough sport, and I know it builds character. But Arthur, why don't you elaborate for our viewers and tell folks what your role is specifically with the Alabama Department of Labor and with respect to unemployment compensation benefits?
Sure, Brad. What's interesting here is that, let me just give them a background on what we as the attorneys here normally do, and then kind of give you an idea of how COVID has changed our situation, because COVID has changed everyone's lives significantly. Normally, the attorneys in this office deal with unemployment claims when I'll use the phrase, kind of get to the back end of contested claims. So let's say somebody applies to our agency and gets unemployment benefits, and they are granted benefits, they're happy, the employer doesn't necessarily disagree, so everybody's fine. So it goes on, and that's that. And they certify every week and they get their check. Oftentimes, either we will disqualify somebody from benefits for a variety of reasons that I'll go over in a second, or will grant them benefits, but the employer will disagree with that granting of benefits. Well, then it becomes contested. It goes through an administrative process. There's 2 steps to that. And then it goes on to, ultimately, it can go on to circuit court. So the argument, if you will, over whether or not we made the right decision by either giving benefits or disqualifying someone from benefits can ultimately end up in court. And that is the bulk of what we as lawyers for the department normally deal with. Now, because of COVID, we have radically changed what we do. First of all, as you know, Brad, the court systems are somewhat shut down.
Right.
Certainly as to jury trials and a lot of live hearings. And then, of course, a lot of non-jury matters are being heard by teleconference, Zoom meetings, that kind of thing. So, first of all, we really don't have the kinds of trial work that we normally would have. And then on top of that, COVID has presented our agency with so many different challenges that many of the attorneys here, and myself included, pick up things on kind of a project by project basis and deal with them on behalf of the agency, which means a lot of internal communications, creating internal teams to deal with certain situations. That's probably the most general way to describe it. One specific instance, for instance, is there is now starting to be discovered fraud in the system. And by that, I mean fraud outside, people trying to make claims on behalf of other people. And so we're developing teams of people, IT people, investigators and all that can deal with that. So there's all these issues that pop up that we never had to deal with before because of COVID. And so now a lot of the attorneys are tasked with dealing with those kind of on a team by team or project by project basis. So there's what we normally used to do and still do a little bit of. And then there's how our roles have changed, again, just like a lot of people's lives have changed because of COVID.
Well, you mentioned COVID, and it's on everyone's minds right now, and particularly with respect to unemployment benefits right now, because as we both know, and as I think everyone knows, the supplemental benefits that have been provided by the federal government expired this past week. And it's still a little bit up in the air as to what will be available once the 2 political parties in Washington sort things out moving forward. But I think it's clear that the amount of benefits probably aren't going to be what they were up until this past week. So for our viewers, we're going to focus on a couple of things today. We're going to talk about the changes, expected changes with respect to the supplemental benefits going forward, and about the unemployment process itself. And then we will make sure at the end of this to open up for some questions that you may have about unemployment compensation benefits. Certainly have an expert here in Arthur Ray to provide responses to those questions. Now, Arthur, I'm gonna turn it over to you in just a moment to give a little bit of a presentation on unemployment benefits that I know you've prepared. But it seems to me, and I was prepared to talk to you about this just before we went live, but one thing that unemployment compensation and bankruptcy have in common is there's a stereotypical bankrupt out there, and there's a stereotypical person who draws unemployment. Pre-COVID, I think a lot of folks kind of had a negative perception as to somebody that sought unemployment compensation or somebody that sought bankruptcy protection. In today's world, and everything's changed, more and more people, of course, are having financial problems. And I think that more and more people will need to seek bankruptcy protection going forward, and certainly have already sought unemployment compensation, people that never thought they would be in a position to do so. But both unemployment and bankruptcy are important safety nets for members of our society, and they're there to help people. So I know you've put together a bit of a presentation here, and I'm really anxious to hear it, Arthur. If you can tell us about unemployment, how the system exists, and what we can expect going forward.
Sure. And let me respond directly to those comments by saying this, because this will be kind of an illustration that will drive home the point that you just made. But there is a huge new group of claimants to our system that, if you think logically through it, it makes sense that these people have always been vulnerable to some degree. And with the closure of businesses of all types, people don't have a hard time imagining that a plant in their town, let's say a manufacturing plant, or up in North Alabama, a chicken processing plant, or in South Alabama, shipbuilders, they close, and hundreds, if not maybe a couple thousand, workers lose their jobs and then file for unemployment. We can all imagine that. But I'll tell you, Brad, one group that really was hit hard in this, and that is people we would refer to as independent contractors, folks who work for themselves. And there's both the traditional view of independent contractors, like somebody who's a sub on a construction site that just puts in electricity, and they can go from site to site, work for company to company, but they're their own business, and that's what they do for a living. But then there's other things that you don't think about necessarily, but that are clearly independent contractors. Hairdressers are a huge group of independent contractors. You get people that do service industry jobs, but don't just work for one employer. And so they organize themselves as an independent contractor. Those folks were hit extremely hard, because not only were they put out of work, but their businesses, in some cases, still have not been allowed to reopen. And even the ones that reopened, they were kind of the last entities to be allowed to reopen. So that was a huge new class of claimants. Luckily, there was a portion of the CARES Act that was able to cover them. So anyway, that's to your point that you made initially. What I'll do is, let me go ahead and first, in case anybody is still seeking to interface our system, try and either get unemployment comp benefits or needs to know about the types of things that we look at. Let me give you just a general background on how the system works, how a claim comes to be, and what kinds of things we look at with that. Obviously, you would go to our website and you submit a claim, and you do what we call is certify, which means you answer a series of, and you'll see at the bottom there, there's our website, and you would go there and you would certify. You would answer a series of questions, fill out information, and establish your claim. Then every week after that, you would have to recertify. That's something that it's in our information, but sometimes people blow by it, and then they'll have a gap of a week and be like, well, why didn't I get paid? So you have to recertify every week. It's short. You can do it online or by telephone. It's a series of about 10 to 12 questions, but you have to answer them. And the most obvious one, and the first question you hit, is, did you work for pay this past week? So it's a weekly certification. You recertify every week. And of course, if you answer that question, no, I did not work for pay, then you work your way through the rest of the questions, because obviously, potentially, you'd be qualified for unemployment that week. So you work your way through the questions, and then we then send a notice to your employer that this person's separated and they're claiming unemployment benefits. It's called a BIN 241. It's a form number, but they then send that back and they tell us how you separated from them. in the meantime, you also have a portion of the question set up where you get to tell us why you separated from them. So we gather facts from you, the former employee, and from your former employer, and then we put them together and say, okay, is there a general agreement about why this person left, and is it disqualifying? Or conversely, is there an argument about it, and do we need to put it through our administrative process? So
And
kinds of
that's
things.
important. That's important as I understand it, because to be eligible, you must have lost your job through no fault of your own. Is that generally correct?
That's correct. That is the overarching kind of mantra for the system is you had to have lost your job through no fault of your own. And so the types of things we look at to determine that are two major areas. One is called the voluntary quit. And I won't bore everybody with the statute sections. This isn't, we're not doing a legal CLE, continuing
No,
legal education. So,
please not.
but
People
there's
will
a
fall
statute
asleep if
section
we do that.
that's right. We don't want to do that. So, but yeah, there's voluntary quit, and what the statute says is that somebody has to have quit their job, and it be for a good work connected reason. So, for instance, if I walk into work and my boss tells me, look, we're going to switch you from second shift to third, and it's that or not. That's all we got right now. And I pitch a fit about it. That's very likely not a good work connected reason. There's case law that indicates that, look, if you got shift change, you have to figure out a way to deal with that.
Sure.
However, think about how different this is factually. However, if I walk into the plant and my boss puts me on the line and says, hey, Arthur, you're going to work your normal job, but we pulled all the safety equipment off and the guardrails off, but you'll be fine. Just keep working. I am perfectly free to leave that job and apply for unemployment because I had a good work-related reason for leaving. I'm no longer safe because my management took safety equipment off.
Right.
So that would be an example of a good reason to voluntarily quit versus not one, legally speaking. Then the second area is over, and this is what's most common, is over discipline related to work. And that is technically the way it reads in the statute is misconduct, either a single instance or repeated after warning. And here's a real important point for everybody to understand because it comes up during trial work all the time. When we say misconduct in the statute, we don't mean misconduct like we all think of, like my 15-year-old daughter doesn't do what I tell her to do. We mean misconduct in an employment law sense, which basically means violation of company policy. So in our statute, the word misconduct means that. So let's think about some fact patterns. I go to work and I am late and my boss writes me up. Then I'm fine for about a week or two. And then I show up late again, boss writes me up again. Let's say the employee manual says 3 lates in a month subjects me to possible termination. So let's say it's the end of the month, it's the last day of the month, bam, I show up late again. I get written up and terminated. And it was by the rules that were established in the employee handbook. Right. Well, that could be adjudicated by us to be a valid disqualification from benefits because I committed misconduct. In other words, I violated company policy and I did it repeated after warning. And I guess in that fact pattern, I should have said the first time they wrote me up, they also warned me. So,
right.
So that's an example of how that could work. Obviously, you can think of counter examples that wouldn't fit the pattern. So 2 main areas, the voluntary quit, and then some kind of discipline-oriented problem. Misconduct repeated after warning. So, and you can see down there at the bottom.
Right.
There's also a second subpart that deals with criminal acts connected with your work, endangering the safety of others, that kind of thing. So there's very specific statutory reasons that we can disqualify. Once you pass through the disqualification issues, then it becomes, as a secondary matter, are you eligible to make a claim? And all that means is you've got to be mentally able and available for work. You've got to search for work while you're unemployed. You have to have had, and this is important. Some people don't understand this. You have to have had in the first 4 of the last 5 quarters of work. Your employer has to have posted enough wages for you to monetarily qualify for the program. So
okay.
if you've, and a lot of people don't know that.
Right.
If you've worked constantly for the last 5 quarters and had anything over minimum wage, generally you'll have sufficient wages to support a claim. But let's say you didn't work all of 2019, then 2020 you come in and you've got a job for a quarter, so 3 months, but all your wages are in that quarter. Then you come to us and make a claim. You will either be monetarily ineligible or you'll be eligible, but for just a very small benefit because it's wage based. So that's one of the issues that we'll look at. So you'll have 2 issues. It'll be, are you monetarily eligible? And then was there a disqualifying reason related to your claim? You go through all that, and if none of that, or I'm sorry, let me say this. If that is contested at any point, if you and the employer argue about discharge, misconduct, voluntary quit, then all of that, either party can appeal. The employer can appeal and say you shouldn't have paid this person, or the employee, the former employee, can appeal and say you should have paid me. All of that then goes through the administrative process, and that's a hearing with a hearing officer. Ultimately, you can appeal that decision to our Board of Appeals, which is live.
Right.
Well, by Zoom now.
Right. As everything.
And then, yeah, exactly. And then if you're dissatisfied with either of those 2 decisions, you can ultimately go to circuit court. And I'll be honest with you, quite frankly, quite a few folks do. And that's fine. These are all rights that you have to appeal. And I'll digress for a second for people that don't know. This is a federal program, but the states administer it. So it's federal, the U.S. Department of Labor. It's the benefit program established by them. They let each state administer it. And so, as I like to tell people, especially judges all the time, the feds are real free with their advice about how we should do our jobs. So, because it is their money. But they indicate to us the general rules. We make the more specific rules, and then we do the work. We get the money out to everybody. So if you go through the administrative process, you could end up in circuit court should you choose to, or if your former employer chooses to, if they push it that far. That is basically how the system works. That is, in a nutshell, kind of an overview of how you would make a claim and the kinds of issues that could pop up, both eligibility and or disqualification in the process of making a claim.
So Arthur,
I'm sorry, go ahead.
So I'd tie this to, and this is great information. I've been practicing law for over 30 years, but I've never done any work in the unemployment field. Just I've had experience as an employer, but it's fascinating information for people, though, impacted by COVID. So if they want to make a claim for unemployment benefits, the first thing is they've had to have worked for a period of time before making the claim. And you say generally, if you've made at least minimum wage for the 5 quarters before the claim is made. And most people, I think, would pass that test that have been impacted by COVID. But then the second test is they lost their job through no fault of their own. So a company closes down. A restaurant is closed down by the state. Certainly, COVID is going to create a situation for a lot of people where they've lost their job through no fault of their own. And I would assume most of those folks would flow straight through to receiving benefits. And I would also ask you, I know you're here in the state of Alabama and you work with the Alabama Department of Labor, but these are federal monies. I'm assuming these qualifications are pretty much the same for claimants in any state. Would that synopsis be pretty accurate?
Yes, yeah. What you'll find is that it's and Brad, you'll appreciate this. They, just like a lot of our statutes at law, are adopted from old model codes that were back in the, I guess, when everybody went from common law to statutory law in the 50s. Model codes that were gone from state to state to state. So, right. Somebody's theft of property in Louisiana, don't use Louisiana because they're Napoleonic code, but the theft of property in Wisconsin is very similar to theft of property in Alabama because everybody worked off a model code. That is true of unemployment rules as well. There were just a set of model statutes and rules put out. So yes, there's very much a similarity from state to state. The difference would be the basic unemployment comp benefit might be calculated slightly differently from state to state. There might be a very slight wrinkle in the difference between what one state says is disqualifying versus another state, but those are all going to be minor differences. And then where they're exactly the same is all of the COVID-related monies that were made available by the federal government were made available as a lump sum amount benefit, and that's applicable to all 50 states. So, for instance, the extra $600 that people receive current on top of regular unemployment as part of the COVID-related benefit, that would be the same $600 here in Mississippi, in Wyoming. That would be consistent. So, yes, that's correct.
That's great information. For non-attorneys out there, Arthur alluded to Louisiana law, and any attorney knows that the law is the same pretty much in 49 out of 50 states. We follow the English common law, but for Louisiana, which follows the old Napoleonic code, and the laws can be just a little bit different in Louisiana. I do want to brag on your department's website, Arthur. I've looked to it, and I strongly advise our viewers, especially here in Alabama, who have questions about unemployment compensation benefits, to go to the department's website. We'll put it up here on the screen before this episode is over. There it is. But just a wealth of information. And what I found interesting is it's not only great information for people, for claimants, people seeking unemployment compensation, but there's great information there for employers and for people seeking employment, for people looking for jobs. There's great information. So go to the website at the bottom of our screen today. Arthur's people have done a great job of putting together information and making it available so that you can educate yourself on the requirements for unemployment benefits. Just a short break here. This is the Bond and Bodis Facebook Live. We are doing these episodes weekly to help people make it through COVID. We're trying to touch upon important topics. Last week, we had a special guest, Chelsey Lambert. Chelsey is an entrepreneur who went through bankruptcy herself. Actually, she and her parents filed bankruptcy separately. She used the fresh start that bankruptcy provides and has done just tremendously well since going through bankruptcy. A real inspirational story for people that may be going through financial hardships right now. Next week, we will have a Birmingham area physician, Dr. Larry Gazzini, and we're going to talk about all things medical concerning COVID. We're going to talk about, should I wear a mask or shouldn't I wear a mask? Wear one. And also about a lot of the information out there on the internet about, true and false information concerning COVID. Larry's going to help us, Dr. Gazzini is going to help us narrow all that down. All of these episodes, including today's, are available on our Facebook pages. So if you know somebody that would benefit from the great information being provided today that may be seeking unemployment compensation, please refer them back to our Facebook page where this recording is available. Arthur has provided just some great information here, and I encourage you to direct your friends to our Facebook page to view this video. The bond and bonus law offices are located in Alabama, Mississippi, and in Knoxville and the Knoxville area in Tennessee. During COVID, we are offering absolutely free consultations with an experienced attorney. We'll do it by phone or video from the safety of your home or office. It's important, folks, to get information right now. Be proactive, reach out, learn what your rights are. Arthur, returning back to the subject of unemployment compensation benefits, we do have some questions from our viewers here that are starting to come in. But if you would, let's talk about the supplemental benefits that provided an important safety net through last week, what the expiration of those benefits means, and kind of what we can expect going forward. Tell our viewers what your views are concerning these benefits and what we can expect.
Sure, Brad. What we've got now and what's been in place since the CARES Act was passed was, and I'm not going to, 2 years of military school, I got bad about using acronyms, but I'm not going to do that to your viewers. But there are a whole series of acronyms for these different programs. I'll only say them once, but I'll relate to them in a way that everybody can follow, and that is this: the way the unemployment process that I just described changed back in late February and March was the federal government came in, passed the CARES Act, the president signed it, and in essence what it did was it took a series of benefits and applied them on top of regular unemployment compensation. So the first thing you had was, I'll only say it once, but it was FPUC, FPUC. That's the $600 that everybody thinks about when they think about the additional federal benefit.
And that's been an important acronym, let me add, for the last couple of months. Yeah.
Yes. And that's what, hey, folks have been surviving. I mean, it really, it was interesting because there was debate. Nobody asked us. I have an economics background. I had some opinions about it, but nobody asked us whether they wanted to tie it to average weekly wage or to average wages or who knows what, the stock market, the cost of living, whatever. Sure. Instead, they just picked an amount, and that amount went to all 50 states, no matter how much you made or what the cost of living was. I have thoughts about that, but they're not relevant here. But,
there's a lot of debate out there. Of course, a lot of people think it was a windfall for people in lower income type states or states with lower cost of livings like Alabama.
Right.
And not so much for people in states with higher cost of living. But you're right; it's beyond what we can. They're not going to listen to us anyway, Arthur. So
exactly,
it is what it is.
So, but that's the initial benefit. If you qualify for regular unemployment comp benefits and can certify that you, in essence, have lost your job as a result of COVID, and here we're talking about everything from a lot of the automobile manufacturers shut down shortly after the announcement of COVID and the restrictions, the governor's order, et cetera. Automotive manufacturers shut down, big manufacturing plants. the chicken plants, the shipyards, all that. So you've got mass layoffs, and then of course you've got anybody who's, I mean, you may have worked for a business, just had 2 or 3 people, but if that business closed because of COVID, then you were eligible for this additional amount. So the first thing you had was regular unemployment, and you would go and make the claim, and then you would say it's COVID related, and we'd add that $600 in. And that is the bulk of what the filings have been. So it's just an additional federal benefit, an additional amount of money. It's set, it's not a percentage, and it just automatically goes on top of your regular claim. The other significant federal program, there's another one in between that, but it really doesn't reach a lot of folks yet. The other significant one is the one that I alluded to when I was talking about hairdressers and things like that, independent contractors. That's one that was called PUA, Pandemic Unemployment Assistance. What that was is that was a federal benefit that said if you are a independent contract, because normally independent contractors can't make a claim against the UI system because they didn't pay into it. Okay. As an employer. So you could be an independent contractor. You can work for a nonprofit. Think people that work for the YMCA, paid workers for the YMCA or for a church or something like that, nonprofit. You could have exhausted your regular UI benefits because initially they only ran 14 weeks. Or, and the last category was simply not otherwise qualified for UI benefits. So it's kind of a catch-all category, right. But the bulk of the initial claimants to that system, that benefit, were overwhelmingly independent contractors, and they'd submit wage information, estimated wage information, and we would pay. And that would then in turn pay them a UI benefit plus $600. So the number would end up the same as somebody that had posted wages under the regular system. So those are the two main things that if somebody's listening and they've claimed into the system, they would have claimed under one of those two scenarios, either as a regular wage employee who then got the benefits plus the additional 600, or as an independent contractor or some other classification like that who got then qualified for unemployment plus the 600. So two different ways you could get there, ultimately get coming out to about the same numerical benefit. So those were the programs that the federal government made available because of COVID. And as you've alluded to, Brad, it is technically the end date is Friday the 31st, but because of the way our benefit week works, you work or don't work through a week, and then Sunday, Monday, Tuesday of the next week, you certify to us that you in fact did not work the week before. So everything we do is in terms of benefit weeks. And so the last full benefit week ended this past Sunday. In other words, because the benefit terminates on this Friday, you can't get another full benefit week. So for all practical purposes, everybody who certified this past Sunday and Monday and yesterday for the previous week, the week that we just passed, would still be able to draw that benefit. Now, unless the federal government does something with the new act, then by next Sunday, Monday, Tuesday, if you were to call in and say, I'm still unemployed, certified that I didn't work for wages and I'm still unemployed, it's still because of COVID, then if nothing changes, you would only get a regular unemployment comp benefit. There would no longer be the additional $600. And I guess now is the time for me to, now that I probably induced panic in a lot of people by saying that, although we're being straight with everybody.
Sure.
Now let me go ahead and tell you what we understand the federal government, Congress, to be working on currently. Should I just go ahead straight into that?
Well, yes, but I just wanted to, I don't think a lot of people know, you said until there is new legislation, people will only receive the regular benefit. I'm not sure we mentioned what would the regular benefit amount be in Alabama. How is that
Oh,
calculated?
yeah. The regular benefit is calculated. It's it basically is a calculated based on the wages that you have earned previously. And so, and without getting too far into the weeds, it's basically the first 8,000 per quarter of every reported quarter that you have earnings. And that's why we say if you're at minimum wage or better, you're generally going to fit into our scheme as far as qualifying for benefits. Benefits range from I want to say the low comes in at 114 a week. I know for sure, but it's subject to that formula. I know for
Right.
sure what our maximum is because it's a hard cap. The maximum is 275 a week. And so if you have relatively decent wages reported, you can get to the 275.
But
So
but we're
that's
certainly
what a
looking,
weekly benefit is.
yeah, we're certainly looking at a big reduction until some new
Correct.
legislation passes for people, at least here in Alabama, and I'm
Absolutely.
surmising other states also. And I'm sorry I interrupted you there, Arthur, but yes, if you can tell us what you expect going forward.
Sure, yeah. No, the what we have heard, and we've been on conference calls with both USDOL and other folks that are interfacing with them, and basically what we're hearing is not a lot different than what you may be seeing reported in the news, although I may have some additional detail. What you see reported and what we're hearing is that at first they kind of wanted to go to some percentage of wages, maybe to address some of those concerns that Brad you had just talked about in response. You know, the issue of is it creating an incentive for people to work or not to work or
Right.
whatever. So there was a lot of talk about maybe going to 70% of somebody's provable wages. Um, Unfortunately, that creates, although Alabama now I will toot I'll toot our horn a little bit because we've modernized our databasing system, and a lot of states have not. At the time that we were at a 90% payout rate and had paid out almost $1 billion in claims here in the state, Florida was sitting on 15% and was mired in non-payout problems.
Yeah.
So that having been said, now don't want to be ugly to our friends in Florida, but it's just a fact that we happen to modernize in time to purely be thankful that we modernized our system in prior to this cataclysmic event. So
Well, we're
anyway,
certainly fortunate in Alabama that you did so, Arthur. Your department's done a great
yes,
job.
and well, and you know, it was certainly not expected, but it was fortunate. Um, what we did was we could retool for the 70% fairly quickly, but a lot of states that can't pitched a fit about it. So then the next thing, and this I think made it into the news, the next thing you saw reported was, well, maybe we'll just do $200 a week, replace the 600 with 200, and we'll run that out for about 2 months, let's say August and September, so all the states can figure out how to calculate the 70%. And of course, instantly you can imagine the comments to that were, okay, so you're going to go to 200 for 2 months, then you're going to flip back to a 70% calculation, maybe a $500 cap on that, maybe not. And a lot of people said, this is insanity. You just need to pick a number and stay with it.
Right.
Because, and the good news for everybody that's listening and anybody who's claiming in our system, the good news is this is kind of glass half full, glass half empty. Let me say this. The good news is it's clear that everybody seems to agree that A, there's a problem, that you can't just drop the $600 and not do anything further. And they seem to be serious about negotiating what that something will be. The only real problem is they haven't settled on what it's going to be.
Right.
What we have heard most recently as a conference call yesterday afternoon at about 5 o'clock, is that there is a strong likelihood that a fixed benefit of some amount, probably somewhere between the 200 and 600, hopefully, will be put into effect. And then let's say it doesn't get signed until next week, they would make it retro to pick up this week that would have, quote, possibly gotten dropped in the process. And then there's still some talk about whether or not to run that out to the end of the year or still get mired in this 70% thing. But I think it's safe to say that both sides clearly seem to indicate that they want to do something. And as is usually the case between the parties over anything, it's a matter of what is it going to be. But that's everything we've heard today.
Well, I think you and I, both as people that work with folks every day that are down and out and need assistance, please, people in Washington, work together and come up with some sort of solution quickly. We don't need fighting over this issue. We need a resolution because people need help today,
That's right.
now, and they can't wait several weeks for something to be done. All right, Arthur, we do have some questions I want to get to before we get to the end here. This is an interesting question. You've mentioned that hairdresser several times. So this person is a hairdresser and says, I had no idea that I was entitled to benefits. I thought that since I'm self-employed, I wasn't. Can I retroactively? Can I go back and file for the months that I was unable to work?
Right. And that's true. There's a lot of people that didn't know that they might be eligible under that PUA, under that kind of other category that captured both independent contractors, nonprofit, etc. The answer is yes. You can go on the website, and you can go on our website, make your claim. Specifically, it'll ask you as you're going through the claims process, is this a COVID-related claim, a PUA claim? You would answer yes to those questions. And then what you'll need to do is you'll need to submit wage information. And there's a number of ways you can do that. We understand that especially at the time this started, nobody had really filed their 2019 taxes yet.
Right.
And of course, the IRS, about the time that everybody was getting ready to file them, the IRS said, no, you can extend them because of the COVID. So a lot of people don't have 2019 taxes. So it's sufficient to be able to show 2018 taxes, 2019, I'm sorry, not taxes, but tax returns that show your income. So a 2018 tax records, tax filing, 2019 if you have it, or a series of 1099s from whoever you may have worked for that show in the aggregate your income level. Let's say that you're an independent contractor but still principally worked with one entity, then you might just have a 1099 from them. So you can get 1099s, you can get your income tax returns, you can, and I think the website indicates there's one other possible way of doing it. I don't remember if it's estimated or what. But anyway, there's a series of things you can submit to us that indicate wages, because as you remember from earlier in the process, all of our benefits, the regular UI benefits, are wage-based. So we have to know your wages before we can calculate your benefits. So if you are a hairdresser who did not know that you were previously able to do this, you can still go on the website. You can indicate that you were out of business because of COVID, that you are filing a PUA claim, and then submit the wage information to us. Now, I'll be honest with you. I don't know what the look back period is. I don't know if it's as much as you can prove wages for, or if it's from filing minus, some number of weeks. That's more detailed than even I've been asked.
Sure.
But that does not keep you from making the claim. And just like we tell people to certify every week, even if their claim is being contested, the same would hold true here. Make the claim, submit the information. as my dad used to tell me about a lot of things in life, he'd say, "Boy, you might as well ask because you got no in your pocket."
Right. That's
You
right.
know. So
There's
bottom
no
line
stupid
is that
questions.
exactly, and there's no reason not to file a claim. Look, if you're not eligible, we'll let you know. But why not file and make sure to see if you're eligible and can be covered by this benefit?
Wow. For our viewers, what Arthur just talked about is worth listening to this episode alone. I am sure there are a lot of independent contractors, hairdressers, just one sector of folks that had no idea they were eligible for benefits. And if you
Right.
lost earnings as a result of COVID, again, we're not sure what the look back period is, but you certainly may be entitled some money. Get your claim in, get your documentation in. Um, uh, Very, very important and valuable information. Arthur,
Right.
another question here. All right, so the federal supplemental benefits have expired. Do I need to refile for unemployment now? You alluded to the weekly recertification, but is there anything special that needs to be done because of the expiration of the supplemental benefits?
Right. Right now, we've not been told of anything. Of course, that's partially because they have yet to quantify. Oh, by the way, for anybody that wants to be able to follow this um, on the internet or anything else, my understanding is they're referring to this as the HEALS Act. The first
Right.
one was the CARES Act. I believe this one's called the HEALS Act, HEALS, I believe. So that's a way to Google it and be able to find information on it. But once they define what that benefit is, obviously, then we'll administer that. But the short answer is no. Assume now, if there, and I cannot even begin to imagine that the feds would require a mass refiling to take part in the new benefit. What I suspect we will be directed, again, because they'll tell us how they want us to do it. What I suspect they'll do is they'll say, have people continue to certify each week and then make that transition into the new program. Obviously, if for some strange reason they demand refiling, in other words, filing of a new claim, that will be splashed all over our website. You will not be able to miss it, I promise.
All right.
What I think is more likely is that they will have us just integrate the new program in and then have you continue to certify.
Uh, Great information. Again, stay tuned to the department's website. A lot of valuable information and updated information, and that website address is again on the bottom of the screen. So I have a question here that came in that says, what if my employer has gone out of business? And I imagine a lot of people are facing this because there's a lot of companies, unfortunately, that are shutting down. How does that impact the claim I've made and going forward?
Sure. And I'm going to go ahead and answer this. And then I think I'm trying to watch the clock. If you want, after that, then I'll address the return to work issue because I know that's
Sure,
hot for everybody right now. But
absolutely.
yeah, if you've got a business that's gone out, then the good news is that unemployment acts kind of as an insurance program. In other words, your employer's been paying in. And by the way, for folks that have worked for a long, long time, I can remember paychecks I got in the early 80s when I was a kid. And that it used to be that unemployment was taken out of your paycheck. But that's not been true since the mid 80s. Since then, it's been employer based, tax based, and then, of course, the feds pay in money too. So your employer's been paying in. So just because your employer ceases to operate does not directly affect your benefit. Quite frankly, the amount of benefits you get, again, without getting too far into the weeds, basically ends up going to a shared cost account that then is spread out amongst all
Uh,
employers in the state. So, but the simple answer is no. The business going out because the business is not paying you directly. We're paying you out of taxes and receipts that were collected from businesses prior and ongoing. So the demise of that business, as unfortunate as it is, will not have a direct effect on your benefit.
Great. That's important for a lot of people, and you're doing a better job of watching the clock than I am. So, yes, by all means, please do address the back to work issue for us.
Right. This is, and I want to make sure everybody understands, this is very important because this is an emphasis that's been put on by the federal government, and that is that obviously a lot of folks are still out of work, and we will continue to supply benefits for all those that are qualified for it. However, you've got to understand that, and again, this lots of times this has to do with like big manufacturers and stuff that laid people off en masse. Now they finally got enough parts together or whatever to start building cars again, or whatever the case may be. So they're calling back whole shifts of people to come back to work. If that's the case, then you have to accept that offer of full-time return to work. Because remember, back when we talked about being able and available for work,
Sure.
well, when people were laid off and it was these temporary COVID-related layoffs, we didn't really enforce the return to work. In other words, we didn't make you go look for another job, because the implication was you were going to have a job to go back to. You just had to get past this COVID stuff.
Right.
And so when they do mass recalls, or even if it's a small business and they say, hey, you guys come back, they're making a bona fide offer of employment to you. And if you refuse that without good cause, that's a disqualification. And it's Tiffany's got it right there at the bottom of the screen. And that's it right there. Refusing a bona fide offer of employment or refusal without good cause to return to work when offered will result in a disqualification. So it's very important for folks to understand. I know it's been tough being out of work, and, without getting into whether or not our benefit was more than the wage or the wage was more than the benefit, the bottom line is, based on the rules that are provided to us by the federal government, if you do not return to work when they offer, your employer offers to return you to work, that can make you subject to a disqualification from the program. And that means the federal extended benefit as well as just a basic UI benefit. So that's something that you need to pay very close attention to. Now, the uphill side of that, if you will, or the more positive way of looking at that is, and I'm reading this, so bear with me, but it's a lot of the PUA benefit analysis applies to this. So these are reasons that you could, even after having been called back, you could be still subject to getting a UI benefit. And that is if a child or other person that you're responsible for is unable to attend school. Now, granted, schools hadn't reopened, so that's
Right.
not necessarily an issue yet. Or there's a child care facility that's closed and you have to take care of them. That could be an exception. It says if the individual is unable to reach your work because of a quarantine. So, if that were the case, that could be an exception. Individual was scheduled to commence employment, but does not have a job or cannot reach that job due to COVID. In other words, your employer rescinded the offer, or there was some quarantine order where they said, look, everybody else is opening up, but we're under quarantine because Skippy on the line got COVID and we're sending everybody back home, or we're not recalling folks. Those are, think in your mind of COVID related reasons that you would still not be able to get back to work. Those are the exceptions that can be made. If your place of work is just simply still closed because of COVID, whatever the direct reason is, if you're, and then of course we've talked about the self-employed. So I guess the punchline here is, if you've been recalled to work, you must return to work. And the way I've heard it expressed is this way: a generalized fear of getting COVID is not sufficient for you to not return to work. Now, there's very specific things that could be going on that would keep you from going back to work. Let's say your employer is incapable of providing you with PPE, personal protective equipment. If your employer tells you to come back to work and says, but we have no mask and no hand sanitizer, look, nobody expects you to work in those conditions, and that it would be ridiculous.
Good.
Yeah. And so those, so obviously there's some common sense things that we look at in that process, but just for an overall broad overarching rule, the general rule is if your employer requests that you come back to work and says there's work available for you, if you want to maintain eligibility for unemployment benefits, you must return to work. Now, that's not saying that if your employer calls you back and you don't want to go back, then that's, you talk to a lawyer about it or some other thing. That may become a private, kind of labor law issue between you and your employer. But as to unemployment comp benefits, which is all, I'm qualified to speak to, as to unemployment comp benefits, you must return to work. And if you don't return to work but continue to certify for benefits, that can be considered fraud. So it needs to be very clear to everybody that the benefits here, if you need it, but if you're offered work and can reasonably return to work, you must do so.
It's, we talked about this at the beginning of the episode. Unemployment benefits are so important for so many people right now, and they're really a safety net. But people, you can't abuse the system. If as Arthur says, if you have the opportunity to go back to work, not only is it the right thing to do, but there can be serious criminal implications. You could be charged with a crime if you continue to certify that you're eligible for benefits. So be careful and do the right thing. Arthur, I can't thank you enough for joining me today. The information you provided is just invaluable. I personally, and I know y'all get a lot of complaints down there, but I personally want to thank you and the other employees with the Department of Labor and other state employees. I know the work y'all have been doing in the unemployment area has been very tough over the last several months, and please know that y'all are appreciated for what you're doing. I do want to thank our viewers. We've tried to provide a lot of information. Again, this video will be available on our Facebook page going forward. If you know that somebody that may benefit from it, please refer them back to this. Arthur mentioned the issues concerning going back to school. We did an episode a few weeks back with Dr. Dale Wisely for parents concerned with that issue of sending children back to school. I encourage you maybe to look back at that. A lot of good episodes. And I remind you that next week we'll have Dr. Larry Gazzini, an internist here in Birmingham, to talk about COVID and the medical aspects and a lot of the truth about a lot of the information you read on the internet. The Bond and Bodis law offices are here to help you. We're offering absolutely free initial consultations. Call us, go to our website if we can help you. We'll do the consultations virtually from the comfort and safety of your home or office if that's what you like. But on behalf of Arthur and myself, we wish you the best. And thank you for tuning in today. Arthur, thank you. Wishing all of you a good day, and we'll see you next week, next Wednesday at 1 o'clock. Thank you, Arthur.